Can I be in priority need if I'm in employment? Now, in some cases where there are automatic characteristics like being pregnant, like having dependent children, the answer is obviously going to be yes. But this question is going to spring up much more with the idea of priority need through vulnerability. Now, there's quite a few videos on the channel about it. We go into quite a lot of detail about it, but it's not something I've dealt with in a standalone video before. And this question came in on the channel yesterday, so I'll read it out. I study and work part-time and had psychosis 2 years ago, and I'm currently still on sertraline 100 milligrams for anxiety and low mood. My mental health team at the hospital sent a letter to them, as in the council, saying that they should put me as a priority need, but the caseworker said that because I work part-time, I'm not in priority need and that is not a serious mental health issue. Next week I'll know the final decision. So a lot can obviously ride on this, and I guess the first thing to say is that lots of housing officers never get good training on priority need at all. And they'll just basically parrot what they've been told by some other colleague, some former colleague or whatever. And it's obviously very convenient for them to take this kind of line. So you'll often see housing officers homing in on information which kind of give this blanket idea that someone isn't in priority need for some reason or other. And as a general rule, blanket policies or blanket understanding of anything really is going to be unlawful. There always has to be a focused assessment of the effects of homelessness or the potential effects of homelessness on a person when you're assessing priority need. And to explain this as best I can, I guess it's just worth going back to the priority need test. Now, again, there's lots of stuff on the YouTube channel already about this. I'm actually going to use a slightly different formulation for this video, which I get from Jan Luber's textbook, Housing Allocations and Homelessness. And it's basically just a rewording of the way I interpret the Smith v Haringey case, which was a Court of Appeal case. It was part of the Paniotu v Walden Forest case. And essentially, in that case, they set out what this threshold is. So if I just flashed it up on the screen, actually just read it out before we get into it. And it's worth saying that this textbook, although it's expensive, it is well worth your money. I've got it both a hard copy and also an electronic copy so I can search it. So if we just go to paragraph 12.87 of the textbook, it says, drawing these threads together, because it's basically a whole kind of prelude to this, it might be said that an applicant who will, if without accommodation, suffer or be at risk of suffering from harm that A, will impact on his or her ability to find accommodation or deal with the lack of it, and B, will be noticeable in extent, and C, would not be experienced by the ordinary person, then they might properly be regarded as being at risk of, basically, like, long story short, that's just basically the definition of priority need. As I say, there's a whole kind of like build up to it in terms of logic and stuff like that, but that's what it's really saying. And the first thing to kind of draw your attention to here is the fact that we are comparing the client, this person who's asked the question, the homeless applicant, to a ordinary person. And this ordinary person, this hypothetical ordinary person, actually is a concept which comes out of another case called Hotak, which is a Supreme Court judgment. And in that case, it explains that the ordinary hypothetical person specifically has no issues. They don't have any disabilities or any health issues or any institutional backgrounds or any risk of abuse or anything like that. There is basically nothing noticeable about them. And the thing that the Smith v Haringey case did, which was very useful, is that it basically changed or substituted the word significantly, which is what we see in Hotak, to noticeable here. And that's important because significant is a word which is quite a flexible word. Basically, it's quite difficult to pin down legally, and because so much relies on it, you will need to pin it down. Whereas noticeable is much easier to understand what that really means. It's basically, would you notice it? That's what it's really kind of talking about. And I guess going back to this question of being in employment, just to make the obvious point, and as I say, this is an obvious point, but it seems that a lot of housing officers don't even understand this kind of thing, is that there are loads and loads of people out there who have various disabilities who are perfectly able to maintain employment. And the priority need test is not a test of whether you can maintain employment. That's not what the test is. The test is, how are you going to deal with the effects of being homeless should you become homeless? And often it's going to be a hypothetical exercise because you might not be homeless yet. And so let's just take a really obvious example where you've got someone, let's say he's a wheelchair user, and they're able to work full-time, perfectly fine, a few adaptations made within the workplace, there's no problem there at all. They're completely able to fulfill their work duties, no problem, all the rest of it. However, if they were to become homeless, particularly street homeless, they're obviously going to potentially suffer some issues which the ordinary person, as in a non-wheelchair user, would suffer if they were homeless. And again, that's a really obvious example. Wheelchair users is something which you can kind of see, it's kind of a physical characteristic. Whereas something like we're seeing here, where you've got psychosis, low mood, depression, that kind of thing, we've got a relatively low dose of sertraline, which is an entry-level antidepressant. We need to be a bit more kind of careful about how we're putting the arguments forward to a council, because you can't see them, because you can't see depression. Lots of housing officers basically think it doesn't exist. That's just kind of seems to be the mentality that housing law basically pushes housing officers towards. you can argue it's not really their fault. They're just kind of in this agentic state, kind of, computer says no sort of mentality. But the fact of the matter is, we can see very clearly that there are not going to be many kind of work or employment situations which are going to have a direct bearing on being homeless. They're two separate issues. I guess to kind of take it, to think about some examples where it might be relevant. Let's say you're a benefit advisor and you become homeless. Well, then your work is going to have some kind of bearing on your ability to find accommodation or deal with the lack of it, because you're familiar with the benefit system, the kind of welfare system, whatever. That gives you a bit of an advantage potentially in terms of dealing with homelessness. Equally, if you're an estate agent, let's say, hypothetically speaking, I guess you're more able to find accommodation, something like that. And I guess to take it to kind of silly extents, if your job is basically, working on Bear Grylls survival shows or something like that, and you're basically, your specialist skill is bushcraft, then arguably you might fare better than the ordinary person would be if you were street homeless. But I think actually that's quite, as I say, it's kind of a silly example. That's not really kind of looking at what the law is actually trying to assess. So that's basically the answer. The answer is yes, you can absolutely be in priority need through vulnerability if you're in employment. But you just need to make the argument still, and you need to basically get the council to actually engage with the issue, because again, these are template letters that the officers are using. Unfortunately, there's a lot of officers out there who don't really care that much, it seems, to actually kind of find out what the truth is, because all this sort of stuff is freely available on Google. 150 quid. I'm sure most housing teams have got a textbook in their office which explains this. They just don't bother opening the thing because it's not in their interest to open up and find out what the law actually is. But certainly any time you see a housing officer saying, oh, you're in employment, you can't be in priority need, you can just basically just disregard what they're saying. But you then need to make the argument. So in a case where we have here, where we've got someone with previous psychosis, and yes, psychosis can be a one-off instance, so you kind of, I guess you need to kind of go back to the kind of facts of the case. But here we clearly have this idea that this person's still getting treated. I guess I'd want to know, was the mental health team in the hospital, was that recent contact with it, 2 years ago? And it's probably worth saying as well at this point, the hospital's opinion that this person's vulnerable is irrelevant, because again, within case law, it's the council's job to decide whether you're vulnerable, because within housing law, that word vulnerable means something very specific. So it's not saying you're a vulnerable adult for the purposes of safeguarding. It's not, kind of vulnerability within a hospital setting. It's a very clear, very specific thing that only kind of comes up in housing law. And so a hospital team, yes, they can provide lots of useful information. What they really need to be focusing in on is what happens to this person if they were to become homeless. That's the kind of key thing. And clearly it would be not very difficult to basically hypothesize that someone with a history of psychosis, which obviously can be a very significant condition, should they become homeless, should that stress level increase, would there be risk of psychosis again? Well, if the answer is yes, then you're going to be looking at someone who is going to be in priority need. So if we actually just run it back through the Jan Luber version of the Smith v Haringey case, so again, for this person with psychosis or historic psychosis but current low moods, currently engaging with treatment, so would that person, if without accommodation, suffer or be at risk of suffering from harm that firstly would impact their ability to find accommodation or deal with the lack of it? So I guess what we're saying right here is that someone with a history of psychosis compared to an ordinary person who has not got a history of psychosis is much more likely to suffer psychosis again. Again, it's not always guaranteed, but it seems to be something which is not too difficult to evidence from even kind of nice guidelines or kind of the ICD-11 or whatever. These are things which you can kind of do a bit of research on and just basically cite the fact that, as I say, someone with a history of psychosis is much more likely to experience it again than a person without that presentation. So obviously if you're having a psychotic episode, that is going to impact on your ability to find accommodation or deal with the lack of it. Certainly, the whole basis of psychosis is that you essentially lose insight into reality, which is going to kind of obviously hinder your ability to find accommodation or deal without it. And then secondly, will it be noticeable in extent? Well, again, if that risk is there, that's clearly a harmful thing in itself. That is clearly going to be something which is going to be noticeable. You would notice a person who is experiencing psychosis because they're homeless, or for any other reason for that matter, but that's something which is not just kind of some trivial thing. Experiencing some kind of psychosis is going to be something which is going to be very noticeable by definition, and as I say, would not be experienced by the ordinary person. As I say, the ordinary person, if they were to become homeless, yes, it's going to be unpleasant, yes, it's going to be stressful, but there's no reason to think, particularly that they're going to suffer psychosis and the harm that it's going to result as a result of that psychosis. So that's essentially the argument you're basically having to make. Now in this case, again, just to kind of give a bit more detail, so the person's waiting to hear what the final decision will be next week. Effectively what the person wants to do is basically get ready for a challenge, because probably the council will issue a perverse non-priority decision. and I say perverse because they have specifically not looked at what they need to look at. They don't need to look at whether the person can maintain employment. They need to look at what would happen to the person if they became homeless. That's the question. That's the thing they should be seeking medical advice from the hospital and so on. But that's kind of what we're talking about here. So be ready for a non-priority decision and get ready to put that challenge in as soon as, basically, because once you get a non-priority decision, assuming this person's in interim accommodation already, which I'm not actually sure they are, but they should be, Section 188 is triggered because there's kind of, obviously there's going to be inquiries to be made. Then once the negative decision has been given, there's usually maybe a week or so left of temporary accommodation, and the person's then got 3 weeks or so to make a challenge to it through the Section 202 review process, which sounds very fancy. But really what I'd be saying to this person is they need to seek and obtain a knowledgeable advocate. Whether it's actually a solicitor, I don't know. I mean, certainly a solicitor would be very helpful here if they can get a solicitor, but there may be some knowledgeable advocates in the voluntary sector, the charity sector, who are willing to challenge them and push back on the council and actually know the law well enough to actually home in on what the actual problem is with this original decision. And if they are to do that, then yeah, basically there's a very good chance I think this person is going to get that decision overturned, but it's going to be stressful in itself. I would also be recommending the person goes back to their GP in the hospital and just say, look, it looks like I'm about to become homeless, I'm incredibly anxious about it. Can we put some stuff in place that should I become street homeless, there's going to be support available for me, just to have a bit of planning for that, really. But that's kind of essentially what the law is. But yeah, just to reiterate, anytime you see the council have these kind of blanket statements, or even something like, oh, you know, it's only depression, you can't possibly be in priority need through depression, that's not true. That's definitely not the way it works. Again, it's about getting the council to actually focus in on what matters. And advocates in this situation can be very helpful here because they can foresee all this stuff and basically ensure that the medical evidence that you're getting is actually going to be relevant to support that conclusion. Because in one sense, the fact that they're getting sertraline and the fact they had a history of psychosis in and of themselves is not going to be really enough to kind of gauge it. Maybe with the psychosis you could maybe cite some resources around and research around the risk of it kind of representing. But you need to really kind of go back to the hospital team and say, look, forget the fact you think they're vulnerable. Tell us what you think is going to happen to this person, or what may well happen to this person should they become homeless. Focus on that and only that. That's what the council actually need to base their decision on. And if the hospital team wants to actually do that, and I would say it's highly likely that they're going to say, yeah, actually, do you know what? If this person became homeless, we are probably going to see a resurgence of these mental health symptoms, and therefore the council will need to take that into account. And they can't really easily dismiss that because it's coming from people with the expertise to make that kind of assessment. So yeah, hopefully that's helpful. This is the sort of thing we cover in the online training. So if you haven't done the training before, and particularly if you work in the sector or you kind of work in some sort of voluntary capacity, I would highly recommend the training because it gives you that grounding, those foundational kind of points of how all this law fits together. There's hours and hours, maybe even a few hundred hours on the channel now. But obviously it's kind of higgledy-piggledy, it's kind of all over the place. And I think the training just kind of gives you that foundation of what a homeless application actually is, what gatekeeping is as well as part of that discussion, why it happens, that sort of thing, and then kind of how you actually trigger a homeless application itself, and you know, kind of all the sort of things around interim accommodation, emergency accommodation, and then that kind of 5-part test, those definitions of homelessness, eligibility, priority needs, local connection and intentionality. If you understand how that fits together, you can then build in it and kind of get an understanding of how everything else fits in with it. So then if you have an issue around this kind of question coming up, you understand how it then has an impact on that person's housing options down the line. And again, if you've got questions about this, at any point really, just put it as a comment on the channel as a what if question. Don't actually name, the fact as this person's actually done, they've talked about it in the first person, which isn't great, but is what it is. Put it as a what if question. What if someone had a history of psychosis, they are on sertraline in the moment, and the council has told them that they're not in priority need because they're in employment? That question there, it will get you exactly the same answer. It means you don't have to put your personal data on the internet. It also gets your brain to work slightly differently and start to separate all the problems this person has, because this person here, they've got the threat of homelessness coming up, but there's probably not their only stress going on. And in one sense, we want to isolate what the legal issue is from the homelessness point of view in order to be able to give a sensible answer, so that person, out of all the issues they've got, can kind of crunch them down methodically into single issues that they can then deal with one at a time. That's the best way, I think, to kind of deal with it. And it's very easy for me to say that I've never been homeless, but I'd say kind of working with lots and lots of people, breaking those big problems down into little problems and using these kind of what if questions as a way of doing that, it just helps your brain approach it from a different point of view. And it goes some way, I think, to kind of helping you see clearly and actually kind of understanding what the argument is you need to make. So yeah, if you put a comment on the channel, or a question on the channel, or whatever like that, I take us the next weekly live stream. We usually do it Thursday evening, 7:30 p.m. Myself, my colleague Shannon, and Will and Karis from Virgo Solicitors, and we'll do our best to kind of unpick them a little bit there, really. But I thought with this question here, because it comes up quite regularly, I'd do a video specifically looking at this issue. So yeah, I hope that's useful. As always, if you find this stuff useful, do subscribe to the channel. You're going to get notifications of new videos. If you give it a like as well, lots of other people will see it, hopefully. And it just kind of helps homeless people push back on councils. Because my own opinion is at the moment really is that professionals, you know, charities, homeless charities, all these people out there, they will not push back. They will not fight for you as hard as they probably should do. The reality is that unfortunately that if you're homeless, you are going to be your best bet, you know, relying on yourself, using this kind of information to put these challenges into the council, using other resources you can kind of dig out as you go along. That's your best chance of actually getting things sorted. So yeah, that's rather depressing, but yeah, that's where I'm at the moment. Really, that's what I think is true. So yeah, but the more we can do to push back on councils, the better it's going to get, just for individual people and for everyone, I hope, down the line.